I'm Randy Bandman, Chair of the Entertainment Law Section of the Beverly Hills Bar Association. Welcome to our program, Hollywood Enters the Legal Battle Over AI, the Midjourney Case from the Studio Perspective. It is my honor to introduce today's speaker, David Schraga. David is a private mediator specializing in entertainment, media, and intellectual property. Having worked on all sides of the Hollywood ecosystem for more than 20 years, David offers rare insight and experience as a neutral. For the first dozen years of his career, David was a trial lawyer focused on cases involving celebrities, entrepreneurs, and bet the company litigation. He trained as a senior associate at the prominent law firm Altshuler, Grossman, Stein, and Cahan, after which he started his own firm, KSW LLP. David then pivoted and for the next decade worked in-house as a studio executive, where he advised studio presidents, mega producers, and other senior leadership. His roles have included Senior Vice President and Head of Global Television Business and Legal Affairs for Miramax, Vice President of Business and Legal Affairs for NBC Universal's International Television Studio, and Senior Counsel for Legal Affairs at Universal Pictures, where he handled negotiations for prominent producers, including Working Title Television, Heyday Television, Carnival Films, Matchbox Pictures, and a wide range of other term deal producers. As a studio executive, David became intimately familiar with all aspects of domestic and international production, oversaw billions in deals and budgets, and negotiated countless agreements with the top agents, lawyers, talent, studios, and distributors in the global television and film industries. With his uncommon background as both a talent-side litigator and an in-house dealmaker, David offers a unique ability to understand and appreciate the complex considerations studios, sophisticated parties, and their teams of representatives must balance while making deals, while in litigation, and while mediating practical solutions to emotionally charged disputes. David was on law review while at the University of Southern California School of Law, extern for the Honorable Dean Pragerson, and received his BA from Yale University. When it comes to community engagement, David is committed to fostering access to justice and promoting mediation. He is the outreach coordinator and a co-host for the Will Work for Food Project, a webinar series on mediation, which also raises donations for food banks worldwide. He serves as a volunteer mediator for the Los Angeles Superior Court, volunteers with the Western Center on Law and Poverty to train high school mediators, is on the volunteer mediation panel for the California Lawyers for the Arts, is a member of the Southern California Mediation Association and a speaker at their upcoming conference, and is a member of the executive committee of the Entertainment Law Section of the Beverly Hills Bar Association. On a personal note, David is the proud father of two young boys, an avid cyclist, a student of the Stoic philosophers, and loves spending time with his family in their garden. Thank you very much, David.
Thank you very much, Randy, for that very generous introduction. I really appreciate it. I think my mom would be blushing for me. It's very warm. And I just want to also thank you very much for your service to the Beverly Hills Bar and to the Entertainment Law Section. You've been a tremendous supporter, and we really appreciate everything you do for the organization. And if anybody's interested in getting involved, Randy is an extraordinary resource along with the rest of the board for the Entertainment Law Section. So thank you for that as well.
Thank you.
Okay, you're welcome. So with that, let's get started. I'm going to go ahead and share my screen. I think that should do it for us, correct?
Yes.
Okay, great. So today we're going to talk about the Midjourney case that was filed by Disney and NBC Universal against the company Midjourney. And what I'm going to try to do today is give you some insight into what the studio considerations are when a case like this is being filed, not just from a legal perspective in terms of what the claims and defenses are, but also from a practical perspective as far as what the business considerations are, what's happening in the industry, and what the future is in terms of where things are going. And to frame our conversation today, what I'll say is that people in studios often talk about and think about themselves as storytellers. When you work in a studio, what people say is our mission is to really tell compelling stories that have exciting characters and propulsive elements and plot twists and and that hopefully tell us a little something about our world and what our values are and the complexity of these issues that we're constantly balancing as human beings. And so today I'm going to try and tell you a story about this case and what I think is a really great and compelling story here in terms of what's happening in the world of AI litigation. And I think it has a lot of these twists and turns. And all of us who are learning about AI and using the various tools that are out there are familiar with the term prompts, and we really know that it's the prompts that will dictate where you go in terms of what the outputs are. And this slide gives you a sense of some of the things that we're going to try and talk about today as we tell this story about what's happening in this case and what the different considerations are. And I just want to emphasize, these are not just the considerations of the studios, but these are the considerations in terms of both sides of this case. And, a lot of what we've seen so far in the course of this litigation has come from the studios. But there's always going to be more that's coming back from the side of the defendant Midjourney, who's answered, and we're still in very early stages. So we're going to try and talk about sort of both perspectives today as well. And I think what you'll see is that this case is really a microcosm of what's going on in the world and in the legal community. I mean, we're in this age of tremendous change. The technology that we're all dealing with is advancing so rapidly. And what we're doing is watching the law try and keep up and evolve in parallel effectively. And it can be very difficult, obviously, for the courts and our legislatures to keep up with this. And so it's really the lawyers who are our peers in this community who are really at the forefront of all of these issues and doing an incredible job litigating on both sides of these cases for all the different stakeholders who are involved. I really tip my hat to them as well. And then, like any good story, this story hopefully could have a happy ending. I guess we'll have to see how the litigation plays out. But since I am a mediator, what I'm going to do is engage in some rank speculation at the end of this talk about maybe some ways that this case could settle and some of the ways that we could think about what a potential resolution should look like or could look like. And then lastly, it's also important to understand today that in large part, there's a lot more questions than are answers when it comes to the issues that we're discussing today because we're in such a nascent stage in terms of what's happening in this world of AI litigation. So I'll pose a lot of them and I'll try and answer any questions we have maybe towards the end, but I can't guarantee I'm going to have many of the answers. So like any good story, there's always an inciting event. There's always something that has to happen to get the story started. And in terms of who the characters are in this litigation, we all know who Disney and NBC Universal are, obviously. But the first question is really, who is Midjourney? And for the most part, the information I'm going to be sharing with you about these companies, about Midjourney, I should say, is laid out in NBC and Disney's complaint. There's other publicly available information, of course, but sort of from a 10,000-foot level, Midjourney was founded in 2021 by an entrepreneur named David Holtz up in the San Francisco Bay Area who had had some previous success as a founder with other companies. So somebody who really knows the community, knows the resources that are out there, and is a successful founder. Midjourney, interestingly, is independent. They do not take venture capital money, so they don't have ownership stake for many of the funds that are out there. They launched their AI image generator software that we're going to talk about in February of 2022 as a bot on Discord, which is another sort of platform to access these types of tools. Although eventually in 2023, they offered their service to customers around the world just through their website. And then eventually by August 2024, it was available to everyone around the world. Midjourney, I guess the question is, how do they make money? They offer a subscription-based model in order to use their service. There's a tiered pricing structure, so it could be anywhere from $10 to $120 per month, and there's other plans available generally. But the idea here is that the more you pay, the more processing time you get, so the more images you can generate in a shorter period of time. You can imagine just the resources that are necessary to generate all these images are incredible. So the more you pay, the more access you have to that functionality. They're a relatively small company in terms of this space. I think they have something like 100 and change employees. But they've reportedly had revenue in 2023 of $200 million. By 2024, they had $300 million in revenue. And in 2024, it also looks like they have about 21 million users. So they're really taking off and growing tremendously. So the first real question is, what does this image generator do and how does it work? Okay, so what I'm going to do is show you some images that are pulled from Disney and NBC Universal's complaint. And we're going to play a little game here. I'll show you the images, and before I advance the slide, you can decide for yourself whether or not you can tell which one is the original copyrighted work and which one is the Midjourney generated image. Okay. So obviously, we all know Deadpool here. The image on the left is actually output from Midjourney. And so the prompt here asks to see Deadpool on a 35 millimeter portrait. And before I go further, I want to just back up for a second and say, whenever we're looking at this type of tool, another important question is to say, well, what is the tool train on? Where does the data come from? Because in terms of these large language models, if you've been following the news, they ingest a tremendous amount of data and they learn how to generate these outputs, right? So the
Hi,
complaint,
David. I'm
yes.
sorry to interrupt. It looks like the screen is currently stuck on your past slides before entering in here.
Do you
Could
see
you try?
Deadpool? Do you see Deadpool here?
No, I don't actually.
Oh,
Could you try to perhaps turn off the screen share and then try it on again?
sure thing. Okay. Okay. Can you see Elsa?
Yes.
Okay, great. So I'm going to go back for a second. Okay. And so actually, let me just jump back to this one. So the question is, what does Midjourney train on in order to develop this functionality? And the complaint explains that the founder had said publicly that they pull off all the data, that pulls off all the data it can, all the text it can, all the images it can. It grabs everything they can, they dump it in a huge file, and they kind of set it on fire to train some huge thing. And the founder of the company has acknowledged that they don't seek consent from the creators of this content before they ingest it and use it in order to train the model. And the question of what did they train on comes up later in some of the cases we're going to talk about, and it presents some interesting issues that the studios in Midjourney are going to have to deal with. So jumping ahead here, we have Deadpool. Right on this slide, you can see it's Midjourney's output on the left, Disney on the right. And the prompt here asks to see Deadpool 35 millimeter portrait. Okay, and our next slide, the prompt here is Princess Elsa singing in front of an ice castle, Frozen animated movie. Okay. Same thing, Midjourney on the left, Disney's original character on the right. We keep going, right? We've got the Little Mermaid here. Which one's original? The one on the right. We all know Bart Simpson. Which one's original? The one on the right again. If we advance to this slide, this one's interesting because the prompt here, let me just jump in here. You can see here that it's Midjourney's output on the right this time and Disney's original character on the left. But unlike the prior slides where the prompt actually specifically referenced the characters, this prompt just says Pixar. And if you just enter the word Pixar, this is what comes up. And so it shows this character Sully, obviously, on the right. And so part of what Disney and NBC talk about in their complaint is that the use of generic terms within the prompts is in generic terms in terms of referencing their company as opposed to specific characters, without even having to invoke the specific elements of the copyrighted works, can lead to these types of outputs. And there are other examples of this in the complaint. If you type in superhero fight scene, it brings up images of Marvel characters. If you put in the word screen cap, it might pull up Spider-Man and Loki and some others. Black armor with light sword, movie screen cap, pulls up, you guessed it, Darth Vader. Okay. And so here's another example. The prompt here is Yoda with lightsaber. Okay. And you may have noticed my bad joke about intent here with this reference to The Empire Strikes Back. But this is something that comes up later. The question of willfulness and whether or not Midjourney is aware of what's going on in terms of these outputs and how it may potentially be able to control these things. And so this is something that in movies they call a little Easter egg, and we'll come back to this question of intent and willfulness later. And of course, the complaint includes many other examples of characters that are being generated in this same way. Buzz Lightyear, Chewbacca, Iron Man, Simba the Lion King, Aladdin, Olaf from Frozen, Minions, Big Boss Baby, Shrek, Kung Fu Panda, Thanos from the Avengers, the Cars franchise with Lightning McQueen, Guardians of the Galaxy, you name it, right? So we're talking about things that really look like copies of these characters that are being generated. And the legal question, of course, is whether or not this amounts to something that's actionable under the Copyright Act, or whether or not there are defenses that Midjourney can invoke. And it does invoke these defenses, of course. And so this next slide talks about something that the complaint describes as the explore feature. And this is where things kind of get even more interesting and juicy from a legal perspective in terms of these claims. The complaint explains that Midjourney has this explore page, and it's a feature that lets you input a search term, and then Midjourney generates examples of various images that have been used or generated through the program, and can really serve as sort of like, inspiration, or I guess a reference point and suggestions for the potential user. So if you put in the term Groot, this is what you would see. Another example, you put in the term Buzz Lightyear, and you get this sort of landing screen in terms of other images that you can see. And as we'll discuss later, the studio seize on this, and they argue that this is a way that Midjourney facilitates and encourages users to generate images that they claim are infringements of their copyrights, obviously. And they're encouraging users to try and generate these results by creating a gallery, and it demonstrates their knowledge of this allegedly infringing conduct. Again, that's the studio's position on this, and Midjourney has answers, and we'll talk about those as well, and defenses. And the real issue is this something that's going to be actionable? And the litigation is going to develop that, obviously. So back to this slide where we talk about the inciting event. And, the real question before we get into a litigation like this is, what's going on before the lawsuit is filed? And, what do you do if you're a studio that has this GA or generative AI platform that's spitting out copies of these copyrighted characters, and they're potentially so good that you can't tell the difference? They didn't pay to train the model, and that they're making money through their program. And what do? Well, you start with sending a cease and desist letter, right? Because you want to try and avoid getting into a litigation potentially, if that's possible. We'll talk more about that too. So what was the timeline that preceded the filing of the studio's lawsuit? Just to kind of go through it quickly, in November of 2024, so just this past fall, Disney sent a cease and desist letter to Midjourney. And what they say in that letter is that you have infringed our copyrights by training on our data without consent and without compensating us, that you're displaying our works through the platform without authorization, and that's an infringement as well. And what they also talk about is that there are no technical measures that are present in order to prevent this from happening. And it's something sort of a term that we refer to generically as more guardrails. And what the studios point out and say in these letters is they ask Midjourney to let us know what guardrails are in place. And what they point out is that there's something of an industry standard in place where companies like ChatGPT, who have these types of similar platforms and can generate images, have limitations on terms of what can be generated. And so if you enter terminology that might result in the display of a potentially infringing work, some of these platforms have technical measures in place that won't let you actually generate the image. And what the studios argue in their complaint and talk about in these letters is the fact that Midjourney does have guardrails that are available or in place to prevent certain things like pornographic content or gore or extreme violence and other things that generally violate their community standards. So this is a big part of what this complaint talks about as well. We'll talk about that some more. So the studios send their cease and desist letters in November of last year. December of 24, Midjourney responds and they say, we're reviewing the letter. Then they kind of go quiet for a while, according to the complaint. In April 25, however, so just a handful of months ago, Midjourney released a new and improved version of his service, and it did not have any additional guardrails in place. Okay, so the conduct that the studios are upset about is continuing. Then in May of 25, NBC jumps in and they send a cease and desist letter to Midjourney. And then in early June, Midjourney teased the release of a new video generator service that they said would work well with their image generating service. And I think this is probably when the alarms really went on within the studios. It's one thing to generate these images, but the bread and butter for these studios is audiovisual content. And now it seems pretty clear that there's a tool that's going to come out that can make videos. And within days of that, the studios filed. Clearly, they felt their hands were being forced. And it seems like there's some other things that were going on also. For those of you who follow Puck News, Eric Gardner is a reporter there who covers the legal beat and does some fantastic work covering the industry, but also has covered this topic. And And what he has reported on this is that apparently part of what really raised the alarms within the studios as well is that around that same time, the government had invited comments in terms of suggestions for what its policy should be on AI. And there were some feedback that came from some of these high-level VC companies that basically said that suggested that the Justice Department should come in on the side of these AI companies in order to intervene and support their ability to train on these types of materials. And so we'll talk more eventually about what the government has to say about this, but that's a big factor, I think, in terms of these folks jumping in and really got their attention. Clearly, it's a tough decision for the studios. They want to avoid this. Generally, they want to try and avoid deep-pocketed defendants. I'm sure they've been paying attention to OpenAI and what they're doing with their platforms as well. But if there's somebody they're going to sue, Midjourney is a relatively better target than maybe some of the more gigantic companies because they're relatively small. Litigators say, don't punch up when you're going after somebody, and you go after a company that has tremendous resources, it can make things even more difficult, obviously. And this case, you can see from the images, it gives the studio a pretty tangible and compelling way to tell their story that this isn't just a case that's about training, but it's about outputs that are really very tangibly look just like their characters, right? So they're going to jump in. This seems like potentially a good way to do it. There's other concerns like, there's precedents in the past where CBS Viacom sued YouTube and that litigation lasted 10 years and didn't necessarily shake out the way the studio wanted. And the studio doesn't want to get into a morass like that. There's a whack-a-mole problem where, you sue one company and another one pops up and you've got to go after them as well. And then there's always the risk of an adverse ruling and not wanting to make bad law that hurts you. But, to some degree, the studio's hand is forced. This stuff is going on. The clock is ticking. They're worried about other factors that could be in play, and they had to do something and jump in. So in terms of the studio considerations when they're filing this type of lawsuit, aside from these sort of big picture issues we're talking about, there's the first thing you sort of have to ask about when you're talking about the considerations is who's at the table at the studio side before a lawsuit like this is filed. And what you need to appreciate is something like this, when it's an industry-wide type of issue, this kind of issue goes straight to the top at the company, right? It's the CEO of the company, it's the general counsel who's going to be involved in these types of decisions. The most senior leadership of the company is weighing in on what the studios are going to do about this, obviously. There's teams of in-house lawyers who advise the businesses, right? The film folks and the TV folks about how they want to deal with these issues. There's teams of in-house IP lawyers like copyright lawyers and patent lawyers and technology experts. There's in-house litigators, there's their outside counsel, and then they're also talking to the production people and the people inside the studio who are working with these tools because they want to understand what the impact of this litigation is going to be on them as well in terms of what they can do. And that's something we'll talk about more as well. So the big point here is there's a complex interplay of considerations for the studios when they're filing a lawsuit like this. They're not thinking about just what the state of the law is, but they're thinking about how it plays out in the court of public opinion, what it means to their business to file. And I think from a big picture perspective, these considerations fall into three categories. They're almost sort of like three legs of a stool. And the first thing the studios are, and there's a tension, I should say, between these competing considerations. And the first thing the studios are really thinking about is the fact that they are libraries. They have invested countless billions of dollars to create these properties, to protect these properties, to go after infringers, to distribute their catalogs. I mean, this is fundamentally the core business of the studio, is to create these types of work and distribute them. And you just look at the work they've done politically over the years to extend the Copyright Act and enhance IP protections for this type of work. Studios are also builders of franchises, right? I mean, the works that we are talking about are the bread and butter in terms of franchises that generate revenue. It's harder and harder in this environment to compete for eyeballs and to make money. And when a Minions movie comes out, it makes $1 billion just in theatrical revenue alone worldwide, okay? And obviously, there's all the licensing relationships, there's the merchandising, there's all the ancillary exploitation as well. So, we are really talking about sort of the fundamental elements of how the studio builds and promotes its business and develops their slates. Like I said, they license these rights, they have licensees, they have exclusive relationships, they exercise tight control over how these properties are exploited, they have very specific approvals over what the images look like. They don't want to tarnish the properties based on what else might be out there. And interestingly, as the technology evolves, the studios themselves are looking at how do they license their own works into the AI ecosystem to try and use the underlying content to generate revenue for themselves, right? So this is a fundamental aspect of what they do, and it's critically important for them to protect their libraries. The other thing that studios think about is the fact that they are people companies with core values. I mean, studios employ thousands upon thousands of people around the world, right? And a fundamental aspect of what they do is they work with guilds and unions. And we've all seen, in the most recent rounds of strikes involving SAG and the WGA, how prominent these AI issues were in terms of what was being discussed and what was ending up in the papers. Um, just in December of last year, Deadline reported on a story that a letter had been sent by the guilds to the studios to sort of point out that there were these various uses of the underlying material that were going on out there. And they asked the studios, what are you doing about it, right? So the studios are under pressure from the guilds who represent the talent to say, we need you to protect these folks. We need you to protect these works, and we need to make sure that they have the ability to be compensated for their work. And a related issue is they have obligations to participants, right? People who participate in the profits of these films and things like that. They need to be paid their share, and the studio is policing things and trying to maximize that revenue. And then the second thing in terms of being people companies is the studios, they want to be the home for the greatest creative artists and talent in the world, right? I mean, you want to have the best directors, the best performers, the best writers wanting to work at your studio. And these people are sophisticated and they want to be able to use these tools, right? They see where the future is going. They see the potential of these tools. They want to be able to create the greatest forms of artistic expression for themselves. And the studios are conscious of that. And they want to create an environment where the artists can come to them and feel like they have access to the best creative environment that's possible. And it creates a pressure for them, obviously, to keep up. And that really sort of ties into the third leg of the stool. And this is where things get a bit more tricky for the studios, because studios are, of course, smart. They want to be able to use this technology for their own benefit, right? They want to make sure that they can provide access to these tools to their production folks, and like I said, their creative folks as well, and enhance the efficiencies of what they're doing too. They are very conscious of the fact that these tools are going to change the world. And so this is where it gets a bit complicated, because it kind of creates a potential contradiction here. And what the studios are obviously going to be concerned about when filing this kind of lawsuit is how not to be seen as talking out of both sides of their mouth, right? Like right now, studios are using these tools in production for post and audio cleanup, for visual effects, for ideation to generate concepts for stories. Um, and and what they'll tell you is that this actually supports their relationship with the talent and the guilds, and it fosters creativity because they're able to save money in certain areas and put more money on the screen to enhance the creative. And they're able to generate more content, create more audiovisual programming in a shorter period of time, and all the boats rise together, right? So but again, the concern for them is how are they seen as, how do they make sure they're not seen as speaking out of both sides of their mouths? Because on the one hand, they want to be able to go to Midjourney and say, you can't train on our tools. You need to pay us. We know we need to have these limitations. And at the same time, they want these tools to exist so that they can use them for themselves, right? And so, I mean, the studios, I'm sure I can say there's a middle ground there in a way these things can coexist, but that's one of the tensions in terms of the optics. And just sort of spoiler alert, and when Midjourney answers, they seize on this and they make a lot of hay out of it. Just other general considerations the studios are thinking about, right? I mean, they're concerned about legal issues when it comes to using this technology, right? Most studios have language in their writing agreements that say writers can't have to represent and warrant that they are not using generative AI technology in their creative process, because there's been guidance from the US Copyright Office that says anything that was created by GAI is not necessarily protectable under copyright, right? So the studios want to make sure that they can protect everything that they're paying for in terms of what's being created. Netflix recently put out some guidelines on the use of generative AI for their productions as well. The same ideas are present. Make sure you're not using it for anything that's original. Don't use other people's copyrighted works as the basis for creation. Let us know everything that you're doing. There's more to it, and all that's out there as well. And then just let's not forget that the legacy media companies haven't had the easiest time of it recently in terms of what's going on in the ecosystem of Hollywood, right? They're in the fight for their lives. Streamers have come in, they've taken market share, Linear is dying, is what everyone says. There's consolidation. And then here comes this new threat, right? It's not a lot unlike the record labels when they were dealing with streaming music and how to deal with that ecosystem. So, faced with the prospect of having to file in the midst of this landscape and all these competing tensions, the studios weren't necessarily looking to jump into this, and they probably waited as long as they thought that they could. The other thing to keep in mind is that every litigation exists within a time and in a context. And something else the studios are going to be thinking about, obviously, when they file is, well, what's the current state of the law and what's happening in the landscape right now? And this chart is taken from a website, a blog called ChatGPT is eating the world, excuse me. And its author is Professor Edward Lee from Santa Clara Law School. He's one of the leading voices on what's happening in the world of AI law. He's an incredible resource. If you're not following him on LinkedIn, if you're not following his blog, this is the place to go to find out what's going on. He's spoken to the Beverly Hills Bar before as well. And this is a chart that he creates, and he updates it pretty frequently to show all the different AI lawsuits or copyright-related lawsuits that have been filed around the country. And this kind of takes us back to early June of 2025. At that point, if we took a snapshot, this is what it looked like in the United States in terms of what the landscape was for AI litigation. And the studio doesn't want to get involved in the middle of this if they can avoid it, right? I mean, this is a morass. There's something like 18 different cases, I think, against ChatGPT that have been consolidated into one multi-district litigation. And there's cases in jurisdictions around the country, and a lot of them, for the most part, are at pretty preliminary stages without a lot of rulings that have already been issued. And Professor Lee has pointed out that even if there are rulings in these different jurisdictions, they're going to be appealed. These are cases of such novel issues and of such national importance. These types of things are going to go up to the Supreme Court before there's real clear resolution on the legal issues that they present. There's been 50 cases filed total since then, if you go to his blog and see the latest. And that was just in the United States. Okay, so this gives you a snapshot of what's happening globally. And of course, these studios are, they're developing shows and producing shows around the world. They're distributing them around the world. And this just gives you a sense of the greater complexity that's really present. So, we're going to try and sort of focus on this issue of fair use and copyright law within this landscape. It's uncertain to say the least. There's probably three main cases to discuss that really inform our considerations today and what the studios have been looking at. There's this one case out of Delaware, the Ross case, and then there are two cases out of the Northern District of California as well. And the Ross case is actually a published decision already. An opinion's been issued, I should say. And in terms of these cases from the Northern District, it's interesting that we'll talk about the history of those. But as of the time the studio filed, the Ross case was decided, and the two cases, Bartz and Kadri, that were in the Northern District, there had been summary judgment hearings, but those cases hadn't been decided yet. Okay, so let's talk about each of those sort of individually briefly. So Ross is what people refer to as a Westlaw headnotes case. The general idea is that this company, Ross, ingested all of Westlaw's headnotes, or something like 2,000 different headnotes, in order to create a competing headnote product. And what Judge Bibas in Delaware found is that on this summary judgment motion was training on Westlaw's headnotes to generate a competing product effectively that was creating additional headnotes for Ross was not a fair use. The purpose was commercial, not transformative. And we'll talk more about some of this, the legal standards for this. But there's obviously a lot more nuance here, but it's very much a fact-specific case about what was being done in that case. And all these copyright cases around fair use are always going to be very fact-specific. And then in the Northern District, we have Bartz versus Anthropic and Kadri versus Meta. Anthropic's tool is Claude. Meta has Llama, obviously. And these are two cases that are filed in the same courthouse in front of two different judges who are one floor apart from each other. Bartz was a class action case brought by book authors claiming that the maker of Claude did two things, basically. They acquired books. Some of them they acquired legally, but some of them they acquired from shadow libraries that they pirated through torrenting sites. They then essentially created a giant archive of materials that they used to train the models. And the general allegation is that that constitutes infringements in terms of the copying and the maintaining of these materials as well. There's a lot more issues, like I said, more nuance, but that's the general gist of the claim. There isn't really an allegation that the outputs that came out on the other end of Claude, for example, um, looked exactly like the books that had been ingested. The books are being ingested to learn how to write and for their knowledge, obviously. Um, the Cod reverse meta case is conceptually very similar. This was brought by 13 authors, one of whom was Sarah Silverman. Mostly nonfiction writers, suing again, claiming that Llama was training on their copyrighted works, that they weren't being compensated, it was done without their consent. They were more conscious or afraid of sort of snippets of their work appearing in the outputs as well. But they also were a bit more concerned about this concept of market dilution, which is a critical factor in the fair use analysis, and saying that these tools are going to be creating and flooding the market with potentially competing works. So again, sort of both of these cases, or all three of these cases, at least the two from the Northern District, I should say, are really fundamentally focused on the act of ingesting and copying these materials without consent, and to some extent using pirated materials. Again, in both of these cases, summary judgment hearings had been held, but there was no decision yet. So then you fast forward to June 11th, 2025, and the studio has to decide what to do. What are we going to allege? How are we going to frame our complaints, our claims? What are the theories going to be? And what they do is essentially four things. Okay. They focus, number one, on the massive investment and money that they have made to develop all these properties. And they focus on this sort of concept that Midjourney is being a free rider. They're making money off of all of their product and they're not paying for it. And the studio needs to be compensated. And the Copyright Act is supposed to protect them and encourage investment. The other thing they do is they focus on the outputs and they don't necessarily focus as much on the training, although they have an issue with that, but they really say, look at what's being generated by this tool. And that's one way where this case is very different from the ones that have come before it. It's really focused on the outputs or what they call the outcomes. They also focus on the absence of these guardrails. And they talk about the fact that Midjourney has the ability potentially to prevent this from happening, but they're not doing it. And they're not doing it because they know that their users want this product and this service, and they're using it in order to draw more people in to make more money for themselves. And then they have this very interesting theory of secondary liability that's built around this explore page. And they say, just look at what they're doing in terms of this explore page. It shows that they're actually taking potentially infringing images, they're putting them out there, they're using them to demonstrate to the users what the tool can potentially do. And they're trading off of this in order to, again, draw more users in and generate more revenue for themselves. Okay, so it really sort of, it goes to the issue of they really know what's going on here and they're manipulating these images to make more money. That's the complaint. Now, again, Midjourney has defenses and we'll talk about those as well. But in terms of this secondary liability theory, it's kind of a way around a lot of different problems for the studios. Midjourney may want to say, look, it's not us. This is just a tool and the users are doing this. And they do allege some of these things in their answer. But the studio is really trying to get away from the concern about these summary judgment hearings in the Northern District and the potential problem that there's going to be a fair use determination that cuts against them and says that learning on these materials is a fair use. And I don't know if I mentioned this before, but at both of these hearings, critically, these judges both said they were leaning towards a finding that the learning on these materials was transformative under the Copyright Act, and it could potentially be a fair use, although there were concerns about the impact on the market. Okay, so one interesting question that's presented by this case is, where are the other studios and the streamers? Right, there's a lot of other studios here in town. Why is it only Disney and NBC Universal that's sued? Well, clearly, in terms of libraries, they probably have the biggest stake in a lawsuit like this. They have, probably some of the most famous, obviously, characters and franchises built around these characters in the world. Paramount, not as much in terms of, what their library is around these types of characters. They're probably also had their hands full earlier this year dealing with the whole Skydance merger and the issues that they were dealing with too. Sony, again, tremendously successful studio, but not the same focus in terms of these types of underlying works. Warner Brothers is the big one, right? They had the whole DC Comics universe. Where were they? Again, Puck has reported on this and said that they were in these conversations apparently, but they decided to back out at the end. And one of the things that Eric Gardner talks about is that you want to be at the table when this type of litigation is going on, because people who don't jump in and aren't part of litigation aren't there when the deals are getting made that dictate what's going to happen. So, and just sort of spoiler alert, WB does come in later, and we'll talk about that as well. Then, of course, where are the streamers? Where is Amazon? Well, they've got the Prime service, but they've also got an $80 billion investment in Anthropic. Netflix and Apple, why wouldn't they come in? Well, I guess, the question becomes, what's the core business for these companies? They are in large part distributors of content. Of course, they're producing and commissioning their own content, but they, in large part, they're licensing content from third parties. And, you kind of have to ask yourself more broadly, what is really the core business of these companies? Folks who work at these companies will say that, they are very much tech companies, okay, with all the benefits that come with that, and different priorities sometimes as well. And so there's an interesting perspective on tech companies and IP that's offered by a professor from USC named Jonathan Barnett, who did a seminar for the Beverly Hills Bar for the IP section, where he basically talks about the reality is that these tech companies in large part are distributors of content, and that content is an input that goes into their system, and inputs cost money. And in general, they don't want to take positions that are going to make it more expensive to utilize inputs as part of their business model. And he does a really fascinating analysis on this. His book is called The Big Steel Ideology, Interest, and the Undoing of Intellectual Property. Okay, so I think you can tell where he comes out on this issue. But obviously these companies like Netflix and Apple, they have their own AI strategies and their own perspective on where the world is going, how they want to use these tools, what they're potentially building themselves, what potential acquisition opportunities are out there. And they're all going to be very conscious of not wanting to take positions in litigation that could ultimately come back and bite them. So right after NBCU and Disney file their lawsuit, the other shoe drops, and Midjourney launches its video generator on June 18th. Okay, but the big plot twist here in our story is the video generator actually contains guardrails. And this time when you enter the prompts that could result in Elsa coming up on screen, Midjourney comes back and it says that prompt violates our community standards and we can't generate that image. Why? It's a fascinating question, right? I mean, the studios would say it's an implicit admission in response to their lawsuit. But, the lawyers on the other side would tell you any types of remedial measures, that they potentially arguably take can't be held against them because it would discourage folks from changing course. Demonstrates that they do have the ability to put these guardrails in place, obviously. Maybe it's just a hedge from Midjourney in terms of limiting their exposure. Maybe it's something different. And spoiler alert, the plot thickens on that as well, too. The next big plot twist comes a little bit later when these two courts in the Northern District come out and they issue their decisions, okay, on fair use. And there's a lot of seminars out there talk about this because they effectively get to the same place, but they take very different perspectives on it, okay? So in terms of the fair use analysis under the Copyright Act, it's a four-factored analysis, but the two main ones typically are the first factor is what's the purpose and character of the use, whether it's commercial or transformative. And then the fourth factor is the potential harm the use has on the market, okay? And on the first factor, the judges basically agree, right? And Judge Alsup says in Bartz that it's spectacularly transformative. Judge Chabria says in Kadri that it's highly transformative. But then the real rub becomes, how do they deal with the fourth factor? And Professor Lee talks about this again, too. There's a fantastic blog out there from Aaron Moss. He's a litigator here in town at Mitchell, Silberberg, and Knupp, who addresses these cases as they come out. Another great resource for you if you want to follow these developments. On the fourth factor, though, they split, okay? And to just back up, Judge Alsup says, training on these materials is really just like the way kids learn. You read something and you learn it and you absorb it, and it helps you create something new that's out there and create additional input, right? And, Judge Chabria sees things differently. He doesn't think that's really an accurate analogy, and it oversimplifies things because obviously these tools have a capacity that your average person who's reading something and writing books doesn't have in terms of flooding the market. Judge Alsop in Bart's, he rejects the market dilution theory. He doesn't see it as a problem, like I mentioned. And what he really is focused on is the fact that some of these books have been pirated. And even if there's a fair use justification for the learning, it doesn't justify theft. So he really focuses on piracy as the issue, and he ultimately certifies a class based on the pirated books. But he says the other learning is transformative and it is a fair use. Okay. Um, Judge Chabria focuses on this market dilution theory. And what he sees is something a bit more ominous, and something Aaron Moss talks about, that really that these tools can become basically a content factory that can just bury creativity under an avalanche of AI materials, as he describes it. And it could discourage authors from being creative if they don't think their work's ever going to be able to break through. And what Judge Chabria says is the potentially winning argument here that the plaintiffs really didn't develop a lot of evidence on um, was the market harm theory. And he kind of gives a roadmap in terms of what evidence needs to be shown in order to win a case like this, and demonstrate that even though it's transformative under the first factor, the market harm is too great under the fourth factor and outweighs that potential transformative use. And he says, you probably need to show the market's being flooded, that sales are declining. You have to quantify the impact of what's going on. These are sort of reading between the lines, I should say, from what he says in his opinion, and talk about how these works, displace human work and really harm the people whose copyrighted images are being used. So he tries to sort of say this is not necessarily a very far-reaching argument that is going to protect the AI companies in terms of how they can train. He really just says the evidence to demonstrate why this is not a fair use hasn't been established. And he's not concerned about piracy. He just sort of sees it as part and parcel of the learning. So, okay, now we're dealing with this split in the landscape of decisions, and we then get the president's statement on AI comes out at the end of July 2025, right? This is the latest plot twist in the story, maybe a month after the studio filed, right? And to sort of focus on the highlighted portion, and maybe some of you remember this coming out, I mean, it does seem like maybe Disney's concerns about what the government was going to say about this were somewhat justified if that was really going on. And the president makes, a point about the need for speed and to be competitive. And he basically says that licensing isn't feasible in terms of his remarks. And there's a lot more that is in the government's policy on AI as well. This is just one very small piece of it, obviously. But it shows sort of where the focus is from the government. And it raises the question if this, licensing, is it problematic? Is it possible? Well, it's something we'll talk about. Ultimately, Midjourney answers in the beginning of August, and they do exactly what you might expect, right? They reframe the narrative and they pose these defenses. And the first thing they do is they come out swinging and they say the studios are talking out of both sides of their mouth. And they're hypocrites because they're these industry behemoths that want to squash the little guy. And at the same time, they want to have access to these tools too. And interestingly, they say in their answer that there's lots of emails from the studios, people with NBC email addresses and Disney addresses who have accounts and are using these tools. And they say you can't have it both ways. And they have unclean hands. And that's sort of the first argument they make. Again, to reframe the narrative and the optics of what's being discussed. They go to sort of Bart's and Kadri, and they focus on the learning aspect of this. And they say we use publicly available materials. And it's not clear where that comes from, but they say we use these materials, and this is just a fair use under these already established precedents. Okay. And again, we'll see how that develops throughout the courts, but they're really hammering on this case, which kind of went, probably the direction that Disney and NBC anticipated, and that they're trying to get around, obviously, by their secondary liability theories. And then Midjourney makes a very interesting argument. They say, well, we're just an ISP. We're an internet service provider. And our users agree to our terms of service. And they say our terms of service say you're not allowed to use our tool to infringe anyone's works. And at the same time, however, our users are entitled to the First Amendment protections. And they are fans, and they are people who want to be able to generate these works for what are potentially very legitimate purposes. And they say, we don't know what's infringing. And it's really the burden should be on the studios in order to send Digital Millennium Copyright Act takedown notices to tell us what's infringing. There's a process they should have gone through here that they didn't go through. Raises some questions. How's the studio supposed to do that if they don't know what a third party is doing? Is it really so innocent, right? The explore feature is something that they don't really fully explain how they're going to deal with that, and in terms of, this, how does the system work? How does the Explore page get generated? What is really available to them? And I think these are all the things that are going to have to be evaluated or developed through the litigation to really get a better sense of how some of this works and whether or not it would be an adequate defense. And ultimately, they make the argument as well that, look, we're here to expand creativity. We are creating these tools that are changing the world. We're not profiteering. And ultimately, they're saying Disney and NBC haven't even identified any harm yet that they're actually suffering. Now, of course, infringement under the Copyright Act is, there's presumed damages, there's statutory damages, and really what Disney and Midjourney are going to have to do in order to move this case forward in terms of an evidentiary perspective, I think, is to be able to show how their licensee relationships are being harmed, how their products are being tarnished, how the absence of guardrails is something that would be available in order to remedy this, how sales could be down, how talent could potentially being shortchanged, and etc. So moving along, then the next twist happens, right? About a week later, the Bart's class action up in the Northern District of California settles, right? And after this finding that the pirated libraries were subject to a trial for damages, and Judge Alsop certified the class, commentators like Professor Lee were doing the math and saying, based upon the number of works that are in these learning libraries, something like 500,000 books, and the statutory damages potentially of, I think, $250 per work for willful infringement, you're looking at potential damages of $900 billion. Okay. And these are company killing damages. I mean, Anthropic, their valuation is about 183 million is the most recent one. Apple is 3 trillion. Okay. So if you're going into this territory, these are company killers. And this is all really just developed in the last week or so. A motion for preliminary approval was filed. There was a hearing on it yesterday. And in the motion preliminary approval, the lawyers say that the settlement is about no less than $1.5 billion, okay, for about 500,000 pirated works in the class. And this translates to about $3,000 per work. It's the largest settlement, they say, in the history of copyright. It's 4 times larger per work than the statutory damages. I guess it's 750, excuse me, for willful damages. So it's 4 times more than they would get potentially for the class members at trial. It only covers past infringement. It doesn't cover things moving forward. And there's some other terms as well in terms of how they're going to identify the class. But, at this hearing yesterday, Judge Alsop actually denied the motion. And he said he still had a lot of concerns about how this is going to be administered, how they are going to identify all the works that are issued, how the opt-out is going to work. He doesn't want class members to feel like sort of a settlement is being forced upon them in this way. And something that Aaron Moss has commented on very recently as well is like, well, is this, he kind of refers to it as a speeding ticket for Anthropic, right? I mean, it's $1.5 billion. It's kind of a cost of doing business. You move forward, you move fast, you don't get permission, and if the product takes off, then you have the lawyers clean it up and it becomes a line item. Okay, so it's a very interesting perspective on this as well. Is it really a deterrent? And so, we'll see how the additional cases settle out based on this. Then after that settlement was announced, right? Then Warner Brothers sues just like a week ago. And now their complaint talks about the video generator. They've got the same lawyers. It's a very similar structure to their complaint and theories. But amazingly, now in their complaint, they say that Midjourney has dropped the guardrails. And they say that Midjourney deliberately removed these protection measures on its video service. And they heralded this change by formally announcing a so-called improvement in their video moderation and touted that its subscribers would experience fewer back jobs. Okay, now Midjourney is obviously going to have a lot to say about this as well. But the message from Warner Brothers is that people wanted the service and they changed what they were doing to make it available. So it's an amazing sort of change in terms of how this works in the back and forth. And now apparently there's a YouTube channel where images that are generated on Midjourney can be viewed, as well as some other forms of dissemination as well. So the scope of what the studios are potentially dealing with here is even larger. Look, the last thing I would say is, how does Midjourney resolve? Okay, one thing you could do, obviously, and as a mediator, we can talk about money, but there's also a lot of creative solutions you can potentially talk about. Is a damages payment going to be enough to satisfy NBC and Disney? Probably not, right? They're concerned about how this is being done. They want control over their IP. And then, of course, even if they were going to take a damages payment, for the past infringement or the learning component, right, they're going to be concerned about the outputs as well. Are there licensing and partnership relationships that could potentially uh, be put in place? I mean, at the last entertainment symposium for UCLA, there was a guy from OpenAI talking about how they're trying to develop partnership relationships with content owners. And is there a licensing relationship? The studios want to use these tools. Is there a way to promote the studios through the results? Is there a cross-licensing relationship that might be available where the studios are using these tools again? And does it end up in sort of a place where they're working together to moderate content on these platforms in order to give users the best experience possible while still protecting the studio IP? Fundamentally, that's sort of, I think, how things shook out and developed in the YouTube universe, and the studios embracing the technology, but doing it in a way with the providers where it also protected their interests as well. So I want to thank you for listening and for attending today. We have a lot of material to get through. If there's any other questions, I know we might have a couple of minutes. I'm happy to stay a few minutes longer. And again, it's just an exciting time to be a lawyer who deals with these types of issues, and our hats are off to the lawyers who are handling these cases, and they're complex issues, and there's two sides to all these stories, and it's really going to be interesting to see how Midjourney continues to respond to this and defend itself, and how the law evolves in parallel. So thank you very much.
Hey, David, maybe just a couple of broad questions for you. I think you touched upon how the studios are considering or dealing with this concept of proactively licensing content. Do you have any other further insights that you'd like to share?
Yeah, I mean, I do think that one of the things that they're exploring is working with like um, different types of companies are definitely are working with like sort of what is the term I'm looking for? It escapes me. With the headsets and virtual reality, right? How do we use our materials in virtual reality spaces? How can the underlying materials potentially be the basis of bots and new tools and interactive AI models that they control that could potentially be exploited in that way? So I think I'll be honest, Randy. I mean, the experts here are probably so far ahead of some of these concepts that I'm suggesting in terms of what the technology could potentially do and what's being discussed, that it really remains to be seen for the practitioner in terms of what else is out there. But I think no doubt about it, there's a lot of exciting conversations that are happening about how to exploit this technology.
Well, thank you very much. So I would just like to tell you that on behalf of the Beverly Hills Bar Association, we truly appreciated your unique insights from the Hollywood studio perspective on AI, and look forward to hearing from you again as both the law and the technology continue to evolve. I guess my last question is, someone asked, do you have any thoughts on the death of copyright?
Yeah, I mean, I think that it's a broad question, obviously, but fundamentally, what we have to think about is what are the incentives behind the act, right? Is it about fostering additional expression from people moving forward in terms of the creative outputs? I think it's sort of the Judge Alsup perspective on it. Or is it about protecting the people who are in the market as well, so that they are continually encouraged to invest the time and money in order to create and aren't flooded? I mean, I think it's just there's such a tension between those two issues, but I do think that copyright protections are important. They serve a very important purpose, and they have to evolve, I think, in parallel. And I think what the studios would say about that is we support these tools. We appreciate that there's an aspect of learning and ingesting what's come before it, but there has to be a way where it can be done responsibly. And I think that's always going to be the balance that needs to be struck.
Do you have any thoughts about how this was dealt with during, I guess someone mentioned radio, in terms of Napster and licensing rights back then? Are there any lessons that can be applied now?
I mean, I think some of the lessons come with sort of how those issues were resolved. And, there are cases out there like the Grokster case that talk about secondary liability. And I just saw something where there's a Supreme Court case that's going to address the standard associated with secondary liability as well. And I think fundamentally, question becomes, do you fight the technology and try and squash it, or do you embrace it? But again, try and have it be exploited in a way that's responsible and takes into account the interests of both parties. As a mediator, we talk about sort of the difference between a party's positions and their interests. And fundamentally, the interests of the studios and the interests of Midjourney have to be aligned if we're going to get a resolution of something like this. And the studios, like I said, they have an interest in protecting their IP, but they also have an interest in moving forward and having access to these tools. And Midjourney, they obviously don't want to be facing a potential, damages award that could kill the company. They want to change the world. So I don't have easy answers, as I said from the beginning, but it's definitely an exciting time.
Thank you very much. We could continue this conversation for quite a long time.
I'll keep dodging trying to give a direct answer because like I said, I'm not sure what
That's your
it is.
talent as a mediator, so thank you.
Yeah, thank
All
you.
right, well, thank you very much, everyone. We look forward to seeing you again soon, David.
Thank you very much, Randy. Thanks, everyone.